Good luck to you, sir. You can go back with the bailiff.
Okay.
Yes, sir.
I think Mr. Parker might be really good.
Haha, you're funny.
I'm getting there. Let's
I'm in
see.
no hurry, Judge. I'm not like robust.
I didn't say earlier.
I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in county court 2 the other day, and it took literally 20 minutes for somebody to do it. Literally 20 minutes. And I was doing rejection. He tried to say, I believe it. I'm gonna go get on Zoom and beat you. So I approached the judge after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he had to wait another hour.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand what could happen if you go to trial and you're found guilty?
Right from the start, you can feel the tension. The judge is calm but firm, laying out the charges in a way that feels almost heavy. And honestly, when you hear 2 to 20 years, it's like the whole room shifts. Moments like this remind you how quickly life can change inside a courtroom. One decision, one moment, and the weight of the law hits you all at once.
Sure.
I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing, what happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury.
This is where we see the first big disconnect. Herbert is trying to talk about details of the arrest, but the judge is focusing entirely on the legal process. It's such a common moment in courtrooms. Defendants feel unheard because they want to talk about what really happened, while the judge only wants to talk about procedure. That mismatch creates frustration fast.
Has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get a...
Here's the thing. Well, here's the thing. The offer is, I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand, if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that
The offer is on the table. 5 years. And what you see here is something heartbreaking. Herbert doesn't fully understand the system. He thinks first-time offense equals lighter punishment. But the judge is reminding him that the DA controls the deal. This is where the power imbalance really shows.
Fencing was actually before you in 2018.
Okay.
2018 for...
Burglary of a building, it sounds like.
Well, the state jail felony was what?
Mm-hmm.
It was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she said.
Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay. That can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Mind if I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
It was a, sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
okay. So it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks.
The prior conviction debate gets messy. Herbert believes something was dismissed. The judge says it wasn't. The attorneys are correcting each other. It's chaos. And from Herbert's perspective, imagine how confusing this must feel. Your entire future depends on paperwork you don't understand.
Just that was this morning, Judge.
Okay.
He has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen,
I didn't get
don't
a
talk
date.
up.
I was attempting
Don't talk over me.
for school, so
Listen.
I was trying to figure out.
Listen, and don't talk for a minute. Because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it. If you do, that's up to you and how you behave. I need to know if you want to take that or if you want to go to jail.
At this point, the judge snaps. And honestly, you can't blame either side. The judge has repeated the same explanation several times. Herbert is panicking, trying to understand time credits and parole. Two people speaking from fear, but in different ways. This is real courtroom emotion.
So you said a quarter of it I'll be eligible for parole.
Mm-hmm.
But he said I have 100, you know what I'm saying, 100 days.
Yeah.
Back time. So
Okay.
I already did, what, like 6 months now, and I got 100 days back time.
So here's the thing. I went to law school because I'm not good at math. I have
That's
no
all I'm
idea.
trying to figure
Well,
out.
do the math. I don't know.
I-
I mean, it's a quarter of 5 is
About a year and
3/4.
About a year and 3 months.
So you know.
This is the pressure moment. The judge basically says, take the deal now or it's gone forever. And whether you think that's fair or not, it's exactly how plea negotiations work. Defendants often feel cornered, like their choices are shrinking by the second. You can hear that sinking feeling in Herbert's voice.
Deal, do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case, you understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you, it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today, because after today, 5 years is gone.
This moment hits hard. Herbert genuinely believes the judge is trying to stop him from beating his case. And even though the judge corrects him, the damage is done once a defendant loses trust in the process. Every explanation starts sounding like a threat.
So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial and you'll be up for trial in whenever the next available trial docket is, and a jury can decide if you're guilty or not. And if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
And here's a final emotional punch. Herbert says, "I didn't do it." That changes everything. Once he asserts innocence, the judge moves immediately into trial preparation. New attorney, new timeline, new direction. Whether Herbert made the right call or not.
Just let me know. We're not we're not going back to a burglary. Okay. Do you want the deal on this one, or do you want to go to trial? Do you want the deal on this one, or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right, I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning, and then I'll take care of it in a few minutes.
No,
If you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If, with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay with you?
After Mr. Miller,
You're going to get who I give you. You're going to get whoever is on next up on the list. So it's probably not going to be him. Okay, he's not on our list anymore. Yeah. All right. So do you want to keep Mr. Parker, or can I give you another attorney?
Okay.
Okay. Mr. Parker's released. We'll give you another attorney.